Welcome to class 23 of Secretarial practice. So in this class we are going to study regarding the rules, conditions for issue of prospectus. So there are some requirements for the issue of prospectus, and if the prospectus in order to be considered as a valid, so it must satisfy some legal requirements. Okay, so here we can say the obligations of SEBI. So issue of capital and disclosure requirements. So it is a regulations according to 2009. So these regulations inter alia deals with the appointment of lead merchant banker, bankers to the issue, registrar to the issue, filing of various documents along with the draft prospectus, so pricing of securities, promoters, contributions, so then the minimum public offer and the disclosure in the offer document. So the company is required to file a draft offer document through a lead merchant banker to the SBI at least 30 days prior to the registering the prospectus with the registrar of company. So the requirements or the rules or the conditions. So the first says dating of prospectus. So date shall be taken as a date of publication of prospectus. So it says that every prospectus must be dated. The date given in the prospectus shall be taken as a date of its publication. So unless it is proved, unless it is proved by the or it is proved to the contrary. So date of filing of the prospectus with the registrar is taken to be the date of its issue. So date of issue of a prospectus may however be different from the date of its publication. So here what you are going to do is you are going to file the prospectus with the registrar. So dating of prospectus and the date what is going to be mentioned, so date shall be taken as a date of publication of prospectus. So the next is it must be registered or registration of prospectus. So prospectus cannot be issued to the public unless a copy of prospectus has been delivered to the registrar for registration. So which means a copy of every prospectus must be signed by every director or a proposed director and filed with the registrar for registration before it is issued to the public. So subsequent issue of copies of a prospectus must state on their face that the copy has been so filed. So the copy sent for the registration must be accompanied with the documents. So whatever you are going to send, it should be followed with some documents. So here it is said that so no prospectus shall be issued to the public unless the prospectus or the copy of prospectus is delivered for the registrar for registration. So this is preserved and authentic record of the term and conditions of issues of shares and debentures made by the company. The next is issue of prospectus. So issue of prospectus must be done within 90 days of its registration. So it should be done within 90 days of its registration. So in the previous points we were studying the documents, right? So the documents. So if the report of an expert is to be published, so his written consent should be there. So registrar, or we can say the written consent of all those persons whose names are mentioned in the prospectus, such as your auditors, legal advisors, solicitors, bankers, etc. So their written consent should be there, and a copy of every contract relating to the appointment and the remuneration of managerial personnel and their consent to the act or to act such as means act as a managerial person also, that should be there. So a copy of every material contract unless entered into the ordinary course of business or 2 years before the date of the issue of prospectus, so that should be filed. So every person making any report, so any report required by your part 1 of schedule 2nd, so all those things should be filed. So here, so these are the documents you have to file it along with the prospectus. So the third point says issue of prospectus, so it should be done within 90 days of its registration. So within 90 days of its registration, so which means here whenever you are going to issue the prospectus, okay, it should be within 90 days of its registration. A prospectus issued after the said period shall be deemed to be the prospectus, but a copy of which has not been delivered to the registrar for registration. Okay, so it will be deemed as prospectus, but we cannot say it as a registered prospectus. So the next we can say expert consent. So expert consent should be obtained. Expert consent or opinion should be, you can get it to be obtained, but you cannot include it in the prospectus. Okay, so we can say expert to be unconnected with the formation or management of the company. So prospectus must not include the statement supporting to be made by, or we can say statement made by the expert, such as your engineer, valuer, accountant. So these are the experts. Unless this expert is a person who has never been engaged or interested in the formation or a promotion or it in the management of the company. So expert consent. So if the prospectus includes a statement to be made or which is made by an expert, it must not be issued unless the expert was an independent person competent to make such report and had given his written consent to issue thereof. Okay, and has not withdrawn such consent before the delivery of a copy of prospectus for registration and the statement that effect appearing in the prospectus. The next is terms not to be varied. So what is this terms not to be varied? Whatever you are going to enter it in the prospectus. So the terms of any contract stated in the prospectus or the statement in lieu of prospectus cannot be varied after registration of a prospectus except with the approval of the members in the general meeting as per stated in section 61. Okay. So what happens here? If you are going to alter, you have to conduct the general meeting. So with the prior approval of shareholders in the general meeting, you can change the conditions of the contracts, so that is stated in the prospectus. So the next is application forms to be accompanied by a copy of prospectus. So which means every form of application for subscribing the shares and debentures of the company shall not be issued unless it is accompanied by a prospectus or we can say an abridged prospectus unless the offer or invitation has not been made to the public. Okay, so no company shall issue the form of shares and debenture unless such form is accompanied by the copy of prospectus. So however, this condition may be ignored if the application form is issued for underwriters. Okay, suppose the application form is issued for the underwriters, you can ignore this. The next is personation of acquisition. So personation of acquisition means if a person who makes an application in a fictitious name to the company for acquiring the shares and debentures shall be liable for imprisonment, so which may extend to 5 years. So here, according to section 58A or subsection 2, so the following provisions of section 68A 1, so it must be prominently reproduced in every prospectus and every application form issued by the company to any person. Okay, so any person who makes in a fictitious name an application to the company for acquiring or subscribing for such shares therein, so what happens here, so it is they are liable for punishment. So otherwise induces a company to allot, register and transfer a share therein to him or any other person in a fictitious name, so shall be punishable with the imprisonment for the terms which may be extended to the 5 years. The last is a disclosure requirement and contents as per the schedule second. So what does this schedule second says? So every prospectus issued by a company must state the matter specified in part 1 of the second schedule to the act and contains the report specified in part 2 of the schedule, and that the said part 1 and 2 shall have effect subject to the provisions contained in part 3 of schedules. Okay, so here what happens, besides the requirements of schedule 2, companies are required to comply with the disclosure requirement as given in SEBI. So it says that whatever disclosure or contents we are going to put, so that should be as per specified in part 1 and part 2 of second schedule, and whatever it is there in part 1 and part 2, so that should be the subject to the provisions contained in part 3 of the schedule. Thank you.